don't know if any of y'all subscribe to like Department of Labor newsletters or things like that, but I do. And I'm getting them daily. And what I'm seeing is links in a newsletter email for me to go back and read more in depth. And I'm seeing lots and lots of willful violations. The Department of Labor going, going after an employer for like a willful OSHA violation. So when we talk about OSHA, we should also be thinking about infectious disease, because that was something we mentioned in the past, that so far that's been under the OSHA general duty clause. But moving forward, we should be thinking, is there going to be an exact specific standard on infectious disease in the workplace, like there is for fall protection or HAZCOM or bloodborne pathogens? So this needs to be on our radar. The other thing that I'm seeing a lot in these emails is a link showing how much back pay and damages and overtime are due for employees. And it's very, we got money for these employees because this employer was wrong. That's the tone of the newsletters and the stories that you read or the press releases. So be aware of that. I'm seeing, like I said, a lot of back pay and damages and overtime. So that is all about the Fair Labor Standards Act. So we refer to it as FLSA, and that very specifically dictates how you need to pay employees. So either somebody is exempt from overtime or they're not. So I'm not going to go too much into it, but that distinction is huge. If you do not know what those terms mean, then you need to. If you don't know what your responsibility is as an employer regarding FLSA, then that needs to be on your radar to become educated about it, because this is what we're seeing. We're starting to see big fines. And as we've mentioned, I think in a previous webinar, the fines are increasing too. And they've ramped up staffing for OSHA. And so all of these things are just huge indicators of how serious we need to take some of these decisions. So two things I want to mention before I move on. One, so if all of your employees should be non-exempt unless they meet an exemption, a specific exemption. So what that means is we call people hourly and salary. Those are not distinctions that FLSA recognizes. They recognize exempt and non-exempt. So you could be salary and non-exempt because somebody doesn't actually meet the rules of a exemption. So it can be tricky. So we need to not just assume that because somebody is an admin in the office that they should be exempt because I pay them salary. Salary doesn't meet the requirements under FLSA. And then if you do pay somebody on a salary basis because they need an exemption, there are strong, strict parameters that allow you to make deductions from their pay. So there's a lot involved in that decision. So, engage us, engage Elizabeth and her team. These are things you need to know about. The last thing I want to mention before I move on is once, the best way to be, to protect yourself from being a union environment is to have that engaged, trust, good culture workplace, because employees that feel they're heard, they feel that they're being treated fairly, they don't need to go seek outside representation to be treated fairly. Okay, so communicating with our employees in a transparent way, listening to them, even if the answer is no, getting back to them and telling them why, looking into it and having a consistent process for the way that you operate, especially before taking any adverse employment action against an employee. Adverse action doesn't always mean just termination. It could be a write-up. It could be a demotion. It could be not getting a pay increase, not getting a bonus. So think about the things that you make decisions on every day and ask yourself, am I improving my environment? Am I engaging my workforce? Or am I disgruntling these employees to the point that they may seek outside representation? And then once that union organizing attempt starts, you are very limited as to what you can say and what you can do with employees and about the unions. So if you get a union organizing attempt, you need to dig down a lot into what the rules are. Well, the Department of Labor just announced that it's going back to, it's called, what is it called? The PROP Initiative, and that is Persuader Reporting Orientation Program. And that is run by the Office of Labor Management Standards. And there's an act regarding this. So this was heavy back in 2011, 2016. And they just put out, I think the 6th of this month, that they are reinstituting this program. And what that means is they are telling you this is a resource for employers to understand what your reporting requirements are in a union environment. So this is significant. So you need to be aware. If you get a union organizing attempt, you need to talk to somebody about what you can and can't do. We might be a resource. A law firm could be a resource. Part of the benefit that you get from Elizabeth's team is access to us, and then we partner with a couple different attorneys, and so they can get involved and help you as well. So just keep that in mind. So I know we're running short on time. You want me to move right into the immigration piece, Elizabeth?
We've had a couple of questions come back through, so I'm going to hit those really quick, and then we can move on to that. So back to COBRA. Let's see. If an employer pays their insurance and they get reimbursed 100%, is the employer supposed to get the money from the employee or terminated employee?
No. So the subsidy means it is 100% free for the insurance for the employee. So that's why the notices are important, because we need to tell them this, because especially people that already got a notice about COBRA, they saw that it was going to cost, $700 a month. So they made the decision, I can't pay that. So they didn't sign up. So the subsidy and the notices are important because it now tells the employee that it's going to be free to you. And it's not coming out of the employer's pocket, but it's not just automatic either. So you need to keep documentation, and you need to apply for the tax credit on your payroll taxes, dollar for dollar, to be reimbursed for the money that you are paying for the COBRA. So let me restate that. The employer is paying for the COBRA. So you're going to pay your health insurance provider for Susie on COBRA, for their family to have COBRA. You're going to pay your insurance company, but you can be reimbursed by the government. So you need to file for your tax credit to be reimbursed for the money you paid for Susie and her family to have COBRA. You need to be reimbursed for that. So you're paying the health insurance company, and you're getting a tax credit on your payroll taxes from the government for the subsidy.
Okay, thank you. And I have one more, and this may be similar, but I just want to ask it. So how does the new COBRA mandate affect employees who are self-insured?
So I believe it covers self-insured employees too. Employers, I'm almost certain it does, but I can make a note and then email you, but I'm pretty sure it does.
Okay, thank you.
Okay. So you want me to send the COBRA notices and then check on that self-insured piece and email you after?
Yes, and then one more has come in on the COBRA notices that need to be sent out. How far back does the employer have to go?
So I think you just have to go back to those that, I'll clarify that in the email. Let me write that down.
Okay.
I think you only need to go back to those that are in their election period, but it could be though, when somebody is eligible for COBRA, they are eligible for up to 18 months under COBRA. So, and state continuance in some cases may extend that. So that's what I'm going to look into. If somebody didn't accept it in their initial election period, which is only a 60-day period, then they still might have been laid off because last year was a bad, year for a lot of employers. So I need to dig into that. So it could be as long as the COBRA period, or it could be limited to the election. So I'll double check that and I'll email Elizabeth.
Okay, and then is it up to the employer or COBRA to send out the notifications once they are offered COBRA after being terminated?
Okay, can you say that again?
Does the employer or COBRA send out notifications once they are offered COBRA after being terminated?
No, it's the employer's responsibility to send out the notices. So what I'm going to email Elizabeth after the call are some sample notices that the Department of Labor has put out. So there's probably a website called cobra.gov. And if you go to that website, it will give you the sample notices and will tell you what your requirements are as an employer. So COBRA is the law, the Consolidated Omnibus, Healthcare Continuation Act or whatever. I just totally messed that up, but we call it COBRA. So that's the law. And then the enforcer of that law is Department of Labor. So it's just a legal requirement that employers have as part of the process when a qualifying event happens. So qualifying event is not just separation of employment. Qualifying event could be a furlough, a reduction in hours because they're on leave of absence, not FMLA, but another leave of absence. And the reason not FMLA is because FMLA wrote into their law that part of the benefit of having FMLA was to continue the insurance as if they were an employee. So a leave of absence or a other qualifying event, like somebody lost coverage. So if an employee that's currently employed through you goes out and somebody lost coverage through somewhere else. So qualifying reasons, sample notices and all that are going to be on probably cobra.gov website. And what I'm going to send to Elizabeth after this call is the sample notices for the subsidy. And I'll send also the list of when we need to mail those out. Some companies, a lot of companies outsource their COBRA compliance to a third-party administrator. Some companies mistakenly believe that their insurance carrier is managing their COBRA compliance requirements, but that's not true. They might be sending out COBRA notices, but they're managing their own COBRA compliance.
So Michelle, I want to, I've been notified by someone in our benefits department at NCW that several of our groups do have COBRA administrators that are sending out those notices. So I did want to let people know that.
Okay. Yeah, and a lot of people outsource the COBRA administration because it's got deadlines and you need to be timely and it's a little bit specialized. So that's a common practice.
And then someone is asking if they currently don't have that in place, do you have any recommendations on how to find third party for COBRA, how to find a COBRA administrator?
I don't have firsthand experience with a company. I don't tend to recommend somebody that I don't have firsthand experience with, but I could include some COBRA administrators in a link or something to Elizabeth after the call, but maybe your benefits team might be more familiar with some third-party administrators that they trust working with.
Perfect. I'll have some individuals from NCW. If anyone is interested in furthering looking into that, feel free to email me and I can put you in contact with someone at NCW or Sanford and Tatum.
Okay. So I think that we should, how do you want to handle the immigration compliance? Because we have 5 minutes. Do you want to just bump it to next month?
Or can we maybe, can you maybe send out some information in the email as well? And then we can maybe follow back up with it again in May.
Okay, so I will send out some information. And then one of the things that I do want to say is DHS has extended the temporary guidance. So like during the whole COVID thing, during the whole COVID thing, I don't know if I said COVID or COBRA, but during the whole COVID thing, people were working remotely. And the responsibility when you're doing an I-9 is that you need to be given the actual documents so that you can touch and feel them and see them, because you need to validate that they are authentic documents. And so the government during this pandemic said that you could delay the touching and the feeling of the actual document. So people could do their I-9 in a remote way. And so they have extended that for an additional 60 days through May 31st of this year. But what I don't think a lot of people understand is when you're doing that, that is just a temporary Band-Aid type situation. It doesn't alleviate the responsibility to still touch and feel and see and authenticate those documents. So basically you're delaying it. So I would only delay it if you truly have to, because it's still on your plate to do later. So anybody that you did and approved remotely for an I-9 during the past year, that should be in an action file of yours that you will have those documents completed no later, the other step of that I-9 process completed no later than May 31st of this year. Also, there's been lots of renewing of documents that has been delayed because of the pandemic. So if you had somebody that's employment's eligibility document expired, there might be exceptions to that rule. So, we have links and things that we check, and we recommend that you check just to see how, what they did in that particular case. If the visa process for some specific country has an extension on it, or what they're going to do there. And we know that I-9 audits have been on the rise. So I was going to go over some basics on managing your I-9s and how you should store and manage that process. And it is something that I think a lot of people just view it as one piece of the new hire paperwork, but the actual I-9 is a legal requirement. Mistakes on the form could have fines. Each form could be up to $2,000 in fines if done incorrectly. So how you store them, how you do them, your documentation, how you dispose of them, what the retention requirements are all very important part of this process and to show compliance for the immigration requirements. And I don't know if I said this already or not, but I-9 audits have been on the rise in the past 10 years. So I would expect that to continue, even though we seem to have really kind of opened the borders some, but that doesn't mean that this requirement's gone away. It really kind of means that you might be faced with more challenges trying to handle this requirement because of the freedoms that are being extended to those that are currently outside this country. So this requirement has not changed, but you might be facing different issues than you have in the past regarding this requirement. And that's time. So it's 11.
I was muted. We had so much to cover. That was like the fastest hour ever. I appreciate everyone joining us. Like always, I just want to remind everyone, as a client at NCW and Sanford and Tatum, you do have complimentary access to Blakeman and Associates. And if you aren't currently signed up, please do email me and I'd be happy to walk you through the steps to get you signed up and in place so you can have access to Michelle and her depth of knowledge, because she is just full of great information always. So I appreciate everyone joining us for April, and I look forward to seeing each of you in May. Go ahead and mark your calendars. As a reminder, this does take place the second Tuesday of every single month at 10 a.m. And I will send up a follow-up email with all the supporting documents that Michelle mentioned. and some information on the I-9s that she mentioned. So have a great week and don't hesitate to reach out if I can assist in any way. Thanks so much. Bye.
Thank you. Bye.
Bye.
Bye.